Hi folks, and welcome back to Contract A. We are doing the video for week 2, and week 2 we are looking at intention to create legal relations. Let's zoom over to our Prezi. Okay, so here we are at our Prezi, and this week, what is in store? Firstly, we'll have a little look at why we need to consider the whole issue of intention to create legal relations. And why do we need to do this? Well, firstly, because it's one of the required elements for valid contract formation, which are, hopefully, you can sing along with me, intention, capacity, there's your two prerequisites, then offer, acceptance, and consideration. They are the main elements that we are looking at this term. Obviously, we need to cover intention to create legal relations because of that reason, but also it has some interesting ties back to theory, so you'll see that we didn't just do it in 1 week and then throw it away. So there we are. We'll preface our comments this week just by quickly touching base with theory. Then we'll head on into the homogeneous case. And I'm going to spend most of this video discussing the homogeneous case. It was the watershed case in this area, thankfully, because when I went through my law degree, this whole area was a thicket of case law that you had to try and get your head around. Thankfully for you guys, it's pretty much just the homogeneous case nowadays. Obviously, there's a lot of other precedent that you can refer to if you have to when you're arguing a particular position, but the default starting point will be the law that was laid down in homogeneous. Then I'll just go back and briefly do a wrap up in terms of the position that used to be before homogeneous and the whole sticky area of presumptions. So let's get on into it. Okay, why bother asking about intention to create legal relations? Well, obviously, not all promises should be legally enforceable. Perhaps if your child's freed, you might think that they should. And that's where we segue very nicely into our theory component. Okay, so if you cast your mind back to our discussions last week, we said that theory really was a way of trying to rationalise, understand, explain a phenomenon to make it a little more accessible to our little human brains. And theory, therefore, looks at what's out there, all the various disparate phenomena, and tries to see patterns in it and therefore facilitate some kind of grand explanation for it all. Now, the concept of finding intention to create legal relations as a way of marking off enforceable from non-enforceable promises has been around forever. And so being a major component of contract law, it is one of the things that, one of those disparate phenomena that any consistent and coherent theory will try and discuss and understand and bring into the scope of the theory. Okay. Now, why has intention to create legal relations been around in contract law for so long? It's because obviously it's a super fundamental, I guess, first step to showing what level of seriousness the parties have in relation to that particular arrangement that they're about to make. There's a really big set of consequences that follow from concluding a legally enforceable contract. What are they? Well, firstly, by choice. You don't have any choice anymore about doing or not doing whatever it is that you said that you will do. If you choose not to do it, then the full weight of the law will be bearing down upon you with some discomfort. Sanctions that you might face. Well, obviously, for Charles Freed, the promise theory guy, first and foremost would be moral approbation. You've done the wrong thing. You've broken your promise. Okay, you can discount that if you wish to. What are the legally consequential things that will flow. Damages, okay, first and foremost, it's going to hit you in the hip pocket. Specific performance is another remedy that the other party may seek from the court, and that is an order that makes you perform your promise. You might also find that if you don't perform properly, then you have some liability under statute. And the big one I'm thinking of there, obviously, can you read my mind? The Australian Consumer Law, which is housed in the Competition and Consumer Act 2010, and we will meet that little beastie later on in term. So just touching base very quickly with each of the theories that we had a look at. What's the essence of classical contract theory? Hopefully by now it's popping into your head already. Freedom to contract. Good old Mel Gibson, yes. Freedom to contract. Contract as a whole must be voluntarily assumed set of obligations, and the terms in the contract have to reflect the will of the parties. Okay, what's one obvious way of ensuring that? Looking for intention to create legal relations. Okay, looking for an intention to create the level of seriousness that goes along with legally enforceable contractual obligations. Okay, what about consent theory? Runs along the same lines. Okay, this is the theory, remember, that says you have to consent to any transfer or alienation of your rights. So this was Randy Barnett, and he says, okay, talking about what you want to do in terms of will theory and classical theory is all very good, but take a breath, take a step back. There is actually a whole set of rights that underpin that discussion. And what he wanted to direct his theory at was those rights, okay? How people deal in those rights, and what theory should flow from conceptualizing contract law as a mechanism for dealing with or alienating, getting rid of your rights, okay? And again, one way of ensuring that you are only enforcing contracts that have been properly consented to in terms of the individuals dealing with their rights is looking for an intention to create that level of seriousness that goes along with the contractual obligation. The manifestation of consent is finding that intention to create legal relations. Promise theory. I do poke a bit of fun at promise theory, but it is obviously one of the major theories that we need to consider. The essence of that theory, all promises should be enforced. Yes, Charles Fried thought that all promises should be enforced as a moral obligation. But should that serious level of obligation and sanction follow from all promises? Yeah, you might think, or perhaps I've incorrectly painted Charles Fried as saying, yes, you have to enforce all promises as legal promises. No, he doesn't actually say that that's the right thing to do. The law obviously doesn't impose that level of seriousness on all promises, even though it might be, fairly slimy conduct that, invites some moral turpitude. So how would Fried, how would he distinguish the promises that should be enforced from the promises that should not be enforced? Intention to create legal relations. Okay, it all comes down to the intent, and this is where intent, will, those theories are fairly closely aligned with promise theory, and he sees this is vital in demarcating off those promises that should be sanctioned by the court and be legally enforceable, justiciable is another word, from the promises that shouldn't. And this is particularly important for Fried because, remember, Fried is the one that says, you know what, actually, consideration, the whole doctrine of consideration, where has to be an exchange of something of value from both parties, mutual exchange for something of value, he says that all goes out the window because, remember, Fried is the one that would like us to enforce gratuitous promises, that is, a promise from one party to another that doesn't involve consideration. So for Freed, intention to create legal relations is particularly important so far as his theory is concerned. So putting that all together, doctrinally and theory-wise, intention to create legal relations is a crucial part in most of the theories that we've had a little look at. And they need to sweep that in, this whole, like I said, if you're going to draw up a theory, you have to look at all of the disparate events and then try and make sense of them, explain them, rationalise them. Okay, now intention to create legal relations has been around forever in contract law, and a theory that swept this to the side would be fairly game. Okay, there has to be some way of marking off the contracts that have the very serious set of consequences like damages and court action and orders for specific performance from those promises that are simply between, members of a family, for example, that are, as you read in your study guides, that are discussing domestic issues, and never for a moment intended that a dispute about that discussion would end up in court. Okay, so it's important for theory. So what does the whole process of finding an intention to create legal relations involve? Firstly, it's all about the factual matrix, okay? The court does not ever delve into a person's subjective intention, okay? So intention in terms of contract law only ever means intention as it is objectively evident to third parties, okay, the reasonable bystander. Okay, so it's an objective inquiry. The difficulty with satisfying the requirement of intention to create legal relations is that normally when parties are creating a contract, often the offer itself will be express. Hi, do you want to buy my car? And the acceptance will be express. Yes, please. However, before they get to that stage, it's not very often that one of the parties will say, hey, do you want to form a legally binding contract? Because I know that it's a prerequisite to legal relations. No. So what you have to do is forensically scout about in the background, in all the facts, to see whether in the bed in which, the factual bed in which the offer and acceptance and the exchange of consideration sits, does that all point to the fact that what was said and done was intended to fall on the legally enforceable side of things rather than the non-enforceable side of things, okay? That's what we need to do. Obviously, very, very tied up with the whole notion of context. Also because intention to create legal relations kind of sits underneath the whole process of offer and acceptance. Often judicially, it will be discussed in amongst, most often, the nature of the offer. So you'll see, for example, in that case note that you did for Carlisle the other week, the court tends to talk in terms of, was this offer intended to be a promise, okay? And there they are saying, what was the character of that offer? What was the intent behind that offer? Was there an intention to create legal relations? Okay, did that offer ripen into a legally binding promise? And so sometimes the discussion might not be super clear and it might actually seem like they're talking about the offer itself, but particularly in the Carlisle case, what they're actually talking about is, what was the character of the offer that was made? Was there an intention to create legal relations behind it? Okay. The other thing that I like when we're talking about intention to create legal relations, and why I think it's good to have it early on in term, is because it's a great opportunity for us to see the whole process of the common law evolving and changing, and judges doing interesting things like distinguishing other judgments. Because given that this relies on context, there's a whole stack of room for differences in judicial interpretation of the facts that make up the context. And so you'll get judges disagreeing with each other. You'll get, as in the case of homogenous, a whole line of authority being overturned. And that's kind of neat to see early on in your degree. Good example of stare decisis in action, or not, if you're the High Court. Okay, so that's probably enough for this particular video. We'll jump on over to the next video for now, so stay tuned and we'll head on into part 2.